SJC-12367, Rachel C. Williams v. American Honda Finance Corporation.
Mr. Roddy, good morning.
Good morning, Your Honor. This case is really about a notice required by a Massachusetts Consumer Protection statute, which is designed to inform the consumer both of her legal rights upon repossession and to allow that consumer to exercise those rights after having been told the extent of them. The UCC and the Massachusetts Motor Vehicle Retail Installment Sales Act, I'll just call that RISA for the sake of brevity, are complementary statutes that have to be construed harmoniously. Section 20B, the plain language of RISA, says for a consumer transaction, the fair market value of the collateral that was repossessed has to be used to determine the deficiency of the consumer.
Mr. Roddy, I imagine this first question is not going to surprise you, but if you look at the Massachusetts Motor Vehicle Retail Installment Act, and if you look at 255BE1, it says fair market value, and E2 mentions retail. And throughout the statute, throughout the Act, when the Act intends to say retail, it seems to say retail. What's the answer to that as a matter of statutory interpretation?
Your Honor, I think the answer to that is the retail value that's used in subsection E2 is invoking the fair market value of the collateral, the term of art that's used 4 times throughout the statute, in the context of referring to the trade publications that a consumer can use as a resource to establish the presumption of fair market value. Now, those trade publications at the time that this statute was amended in 1974, through the present, Honda's Black Book, in fact, follows this same protocol, typically have 3 ascribed values. There's trade-in, there's wholesale, and there's something called retail value. If you look in the appendix, Honda's Black Book ascribes retail value of $9,800 to Ms. Williams' car. So the legislature used that as a modifier to clarify that it's the retail value portion of the Blue Book, the NADA Guide, or Honda's Black Book.
Well, then why did they set up a presumption in E2?
I believe they set up the presumption in E2 because this is a consumer protection statute, and for a consumer to determine or to show what the fair market value of the car was in a deficiency proceeding, given consumers limited resources, simply going to the established Blue Book, which costs a minimal amount, and saying to the court, this is my presumption, enables the beginnings of the court to determine what the fair market value is. I think, however, it's almost indisputable that the fair market value can never be the auction value, because the purpose of the auction, and here typically, as is the case, Ms. Williams' car was sold at a private dealer-only auction. Dealers go to the auctions to buy cars at a price that is less than they can later sell them for at retail on the lot. The auction proceeds could have been used prior to 1974 to determine the deficiency calculation. But as Judge Queenan says, as the First Circuit recognized and as the magistrate recognized, Section 20B changed the rules and requires the fair market value mandate to be applied to a consumer's deficiency.
Well, put aside the contention about whether or not it's better for consumers to have the cars sold on the lot or at an auction. Just put that aside for a moment. Let me just make sure I have your argument. Your argument is that while you have fair market value in E1, in E2 you have a presumption of retail, but you're saying the presumption is not related to retail. It's related to looking at, for instance, the Blue Book value or some other resource. Is that right?
Two clarifications to that, Your Honor. First, we're not arguing that the dealer is or the creditor is obligated to resell the car at retail, just to take the retail value arrived at in good faith and apply that toward the consumer's deficiency versus the auction proceeds. Number two, subsection E2 sets up a procedure that's enabled to help the consumer when a deficiency proceeding comes before the court. The retail value that is mentioned there corresponds to the category in these trade publications that sets the so-called retail value, just as the Black Book does, using those precise words. That's the fair market value that we're referring to, is what the legislature is telling the court, telling consumers and defense counsel in subsection E2.
Mr. Roddy, in practice, so what are you saying that Honda or whatever manufacturer would consult the Blue Book, whatever condition the vehicle is in, that would be the deficiency amount. That would be the amount that goes towards the deficiency. Whether the consumer would be credited that amount, and if they sell it at auction for more, they sell it at less, it doesn't, well, I guess if they sell for more, it's a different animal, but if they sell it for less at auction, it doesn't matter, right?
Really, it's a bit of a nuance. It's not that the creditor is required to take...
Maybe I should let you describe how that would work rather than me try to paraphrase.
Well, I will say this. The case is really about telling the consumer what her rights are. The fair market value may be something different than what the Blue Book says for various reasons. And the creditor can try to establish that, whether in the context of determining the deficiency or in the context of a deficiency proceeding to rebut the presumption that the consumer is entitled to.
And how does the creditor do that, Mr. Roddy?
Well, the creditor actually has a variety of resources. Dealers can use their own appraisers. They can bring in experts. They can point to deteriorating conditions in the car that may not be reflected in the Blue Book categories. But essentially, you've got a ballpark figure for the fair market value of the car that's set up in what I'll call the Blue Book. Here, Honda's Black Book says $9,800. So it's $900 more than they gave Ms. Williams credit for. But the important point here is Honda didn't even try to give Ms. Williams credit for what it thought the fair market value was. It's just after the fact justifying what it did by saying, well, the auction proceeds are the equivalent of the fair market value. And the entire legislative history and a sensible interpretation of the law, which is designed to protect consumers, precludes that conclusion.
I don't follow that, though. I mean, they have the same incentive. Why don't they have the same incentive of getting the most for that car? They've got someone who's not paid their loan. Suing that person is going to be difficult. Don't they want to get the maximum value out of the car up front? So I don't understand why the auction isn't a good measure of the fair market value. I can see why there may be a difference, but I don't see why they have an incentive to sell for less.
Well, I think there are two reasons for that, Your Honor. Number one is, in 1974, that's how the deficiency was determined, and the legislature found that was harming consumers and changed the rules to say, use the fair market value instead.
They're talking about the deficiency lawsuit, which is a second component of this. I'm focused on the first step first, which is the auction, and why that isn't a good fair market value. I understand that if they're going to go sue the person who didn't pay the loan, then we've got a different set of considerations going on here. But it seems to me that the first step, I don't see why their incentives are different from the customer, which is to get the most money out of this. And also, I don't understand how yours is going to work in the real world because, I understand lawyers can sit around and argue about value, but they've got to sell the car quickly, and they've got thousands of these going on.
Exactly. The economics of the marketplace dictate that the creditors have to sell the car in an efficient manner.
Right.
And they do get the
And to get the most money for the car, because suing these people who didn't have enough money to pay their car loans is no easy business and probably fruitless most of the time.
So the creditor can get through the auction process the most available given the economic constraints it's subject to. That will never be the same as the fair market value of the car.
Why not?
Because the fair market value, well, the practical reason is dealers go to the auction to buy cars for resale. If the dealer buys the car for
But
X,
those are the dealers. We're talking about the person who owns the creditor wants to get the most out of that car, doesn't he or she?
yes,
So, and I get your second point, which may be, if they go ahead and do that that lawsuit afterwards, then I see why the legislature is putting the creditor on notice that, okay, you should have gotten a good price for that car. There I can see maybe it's I can see why there's a presumption on retail to force the person who's suing to push it, to make sure that they do a good job selling it. That I understand. Again, I don't know how that's going to work in the real world with all these notices, but go ahead.
in Section E1, which is not a contested proceeding, the fair market value of the collateral formula also applies with equal force. As the term is used 4 times within the space of approximately 100 words within the statute, it has to mean the same thing in each instance.
Then why would they call it a presumption in E2? Why wouldn't they just say retail market value in E1, retail market value in E2, but they don't. They say fair market value, and then they have this presumption about retail sale value.
The way that it makes the most sense to me, Your Honor, is that the nature of the publications from 1974 through today set up essentially 3 different values to look at when you're trying to determine which one to apply. The only one that would apply to a consumer transaction that fits within the context of the purpose of this legislation is the category called retail value. So those words retail value were essentially copied verbatim from the Blue Book of 1974 and exist verbatim in the Black Book of today. Secondarily,
But that means,
I'm sorry.
But then it sounds like it's a lawyer's process, not a business process. The lawyers are going to set you've got these books which have 3 different values, and then there are also multiple components, right? We're going to decide whether the car is in good condition, whatever, medium condition, rough condition. It's not a market, it's a litigation, it sounds like.
Well, in the first instance, Your Honor, we don't even get to that in this case, if I would say so, because this case is really about how do you describe to the consumer accurately what her rights are upon deficiency. How is her deficiency calculated? Now, Honda knows that you're supposed to apply the fair market value, makes a distinction in materials that are confidential that I can't speak about here in open court, found the exposition in our brief at page 12 and in the supplemental joint appendix at page 12. Its own confidential documents. So knowing that this particular statutory condition applies, it nevertheless chooses to use the commercial proceeds formula, which is the same that's applied to some trucking company that lost its truck to repossession. That was the case way back when. It's the very reason that the legislature changed the law. If the legislature thought for 1 minute that the auction proceeds, regardless of the incentive the creditor may have to get the best possible auction price, were in any way equivalent to the fair market value of the car that it wants the consumer to get credit for, there would have been no need to enact any of Section 20B, nor to use fair market value 4 times within the space of about 100 words in the statute.
Mr. Roddy, what's the benefit of notice to the consumer? What's the goal?
There's 3 benefits, Your Honor. First, the consumer is entitled, and I should add, this is enforced through Chapter 93A, which is intended to protect consumers, the basic purpose of which is to let the consumer know all the material terms of the transaction before the transaction is consummated. Now here, the consumer has already lost the car. The consumer is wondering, how much am I going to owe? If it says you're going to get the auction proceeds minus the loan balance, the consumer is left with nothing. There's no way to figure out what that's going to be. If it says the fair market value of the car, the consumer is A, told that they're going to get an amount that is actually discernible. Go look at the blue book. You know your car's in bad condition. You see it says $9,800. You have a sense of how much that's going to be. Secondarily, it decreases the deficiency liability of consumers across the board because the auction proceeds will always be less than the fair market value. And third, by misstating the law, that's a harm in and of itself because consumers are entitled to know exactly what their legal rights are in a statutory notice that the creditor is obligated to provide. This court addressed this issue in a related sense in the Pinty versus Emigrant mortgage case and found that by misstating the consumer's rights, suggesting that the consumer had a defense to a judicial foreclosure action here in Massachusetts when, of course, no such foreclosure action would ever be commenced, misled the consumer and invalidated the notice.
So your analogy to Pinty is it that this safe harbor notice within the UCC has to have infused into it the fair market value under E1?
The statute does say, unless displaced, UCC Article 9, Section 6 will apply. And in addition, the safe harbor notice contains a little paragraph that says, the proceeds that we get minus the loan balance will apply or will not as applicable. Here, it's will not as applicable. Put fair market value in there instead.
Doesn't have to say retail, it just has to say fair market value?
Yes, the exact wording that the statute provides.
Okay.
All right, thank you.
Thank you.
Mr. Mattson, good morning.
Good morning. May it please the court, Eric Mattson on behalf of Defendant Honda. This court has been asked by the First Circuit to answer 3 questions of statutory interpretation, and I would respectfully suggest that all 3 can be answered by applying the most basic rule of statutory construction, which is just to read the words that the legislature has written. So the first question for this court is whether...
I'm sorry, if we do that, don't you lose?
Not at all.
The words are fair market value, and then it later clarifies that that meant retail fair market value. How do you win if we use the language of the statute?
Because the language of the statute says you have to use fair market value. It does not say you have to use fair market retail
Okay,
value.
so you're saying that there's a different definition between E1 and E2.
Well, I would say, first of all, that E2 does not provide a definition at all. It provides an evidentiary presumption.
But why would the legislature be so foolish to establish an evidentiary presumption of the retail value when it's not the retail value?
Because a presumption here, in this context, like any presumption, can be rebutted with other evidence.
I understand, but
For
generally,
example,
you do a presumption that is supposed to mirror what in most instances is the accurate result. Otherwise, it's a rather foolish presumption.
I don't think it's a foolish presumption. It's a presumption is an evidentiary tool for judges and juries to use to resolve cases in an efficient manner. But in the case of every presumption, it can be rebutted with other evidence.
I understand, but if we're going to do, if you're right, and if the legislature was not being silly, wouldn't the presumption be the actual sale price of the vehicle when it was sold? Wouldn't that be the presumption?
No, because we're talking about 2 different contexts here. We're talking about one context where the creditor has to provide notice to the debtor of the creditor's good faith belief of what the fair market value is of the car. In this case, that is exactly equivalent to what Honda was able to get in a competitive auction for the sale of that car. If Honda then takes the next step and then sues the debtor to try to recover that deficiency that Honda has calculated, then the presumption kicks in. The presumption at that point, which is not our case, is that the fair market value is a retail value. Okay, so that's what happens then. But in that circumstance, Honda can then present evidence, for example, as plaintiff has admitted here, that it undertook steps to obtain the highest possible price for this car to try to persuade the judge or the jury that it did, in fact, obtain fair market value. It has overcome the presumption. If you look at Section 301 of the Massachusetts Guide to Evidence, it talks about a presumption and how we treat presumptions. They exist, and then once the the other side, the person opposing the presumption, comes forward with evidence to rebut the presumption basically disappears.
But
So-
it also means, and we've also said, that in the absence of other evidence, the presumption prevails.
And correct, but
So,
but again,
but you're saying that's, if that were to be the case, the presumption is wrong because that presumption is based on the retail fair market value, when in fact it's the wholesale fair market value that the legislature intended to be the measure.
I'm not saying that the legislature intended, in particular, specifically retail or wholesale. It intended a fair market value to be used.
Well, it has to choose one, doesn't it? It's a different,
no,
it's a
of course
different,
not.
it's a different fair market value.
It does not have to choose one. If it wanted to choose one, it could have. And in fact, that goes back to the first point, which
Then
is.
what does it mean if it's wholesale is going to be lower than retail? That's why people make money selling retail. How is the wholesale fair market value going to be equal to the retail fair market value?
I didn't say that it would be equal. All I said is that the legislature specifically used the phrase fair market value. If it had used the phrase fair market retail value, we wouldn't be here today. This lawsuit wouldn't have been filed because Honda would have been using the fair market retail value. Yes, please.
If then you, at the auction, sold the car for, or the vehicle for more than what would be considered the fair market, the trade value from the trade value, the trade books.
Yes.
If it was more than that, you would not be obligated to refund that. You would just be obligated to deduct, rather. You'd just be obligated to deduct the amount in the book.
What Honda would do in that circumstance is provide credit for the full amount that it actually obtained at auction.
Now, is that because of an internal policy, or is that because that's what the statute would require?
I think that Honda would have a tough time deciding to play both sides of the issue in this instance. If it obtained more than fair market wholesale value, more than fair market trade in value, more than fair market retail value, it would have a very difficult time in court persuading any judge that it should not credit that full amount. And that is, in fact, what it does day in and day out. Remember, here, to go back to a point that I believe Justice Kafka made, we're talking about a situation where Honda has every incentive to wring every possible penny out of these sales. And in fact, it uses the same system to sell cars that it's repossessed as it does to sell cars that come back to it at the end of a lease. So it's trying to get the most money it can. But to return to Chief Justice Gantz's point, we are talking here about two fundamentally different issues here. If the legislature had chosen to impose a rule of fair market retail value, Honda would have found a way to follow that rule. So in a sense, I agree with Mr. Roddy that this case is about notice, but it's really about fair notice to Honda and other creditors. If the legislature had put in a formula, like Connecticut has done, saying you use some from here, and that's the amount you credit, Honda would have followed that rule. What Honda has done here is done its best to apply the fair market value that it believes applies to these cars, and it's done that in the case of Ms. Williams, as it's done with other customers. And we are talking about two different things here when we talk about a definition, right? If the fair market value had been defined to mean fair market retail value, this would be a different case.
But why do they put in the retail? I mean, I understand your argument if they didn't put in the retail in the second one. Is that because they want I buy your first part, which is that they have the same incentive to, get the most out of the sale. But then the legislature has given, if you go that second step and sue, which I don't know how often that happens, the legislature is saying they're changing the game a little bit by putting in that retail. Aren't they? I mean,
they're changing the game a little bit.
Just to finish with the chief's point, which is that, it is odd to include, because if they'd just written fair market value in both provisions, your thing would work neatly. But when they pick a number that's always going to be different than the number you're picking, right? Because we know that the wholesale price is going to be different than the retail price, right?
Almost always, yes.
So they put
At least a little.
So they put in a presumption that you have to disprove in every single case. It's just odd, isn't it?
There are plenty of statutory provisions that are a little odd, but in terms of actually applying
But it's particularly because it's done in the 70s, right? When these auctions are not as efficient as they are now.
Right?
So maybe they're worried that you're
They may be worried that the creditor is gaming the system and hoping to come after the debtor to
Right.
collect these deficiencies. Maybe, and I don't know enough about the history to know, maybe that was much more common in the old days. Honda, I can't quite go as far as saying never, but almost never.
Yeah, but that doesn't
sues.
matter, because we're looking at what the intent was of the legislature. Let's assume Honda's a good doobie, but the fact of the matter is, the legislature passed this in 1973 because there were a lot of car dealers who were not good doobies. Isn't this a reaction to the fact that there were many people who were abusing the system? This is, you're suffering from the sins of the mostly American car companies in the 70s who were doing this. So the fact that you're honorable doesn't matter. We're looking at legislative intent.
And the best evidence of legislative intent, to come back to where we started, is the actual words they used. This would be a different case if they had even, instead of creating a presumption in E2, had said that in a proceeding for a deficiency, the fair market value shall be the retail fair market value. That would be a different case than what we're talking about here. They didn't do that. They just said, first, that the fair market value is a question for the court to determine. A question for the court to determine, and then it goes on to create this presumption, which by its nature is rebuttable as soon as Honda or some other creditor comes in with evidence to say, hey, Your Honor, what we got at auction, or what this other number that we think is a reasonable fair market value is the number you should apply. That presumption disappears.
But going back to the good doobie theme, okay, so you basically do this as you did, and you tell the plaintiff here, you owe $4,713.
Right.
Based on how much you sold. And if this person is a good doobie who basically says, I pay my debts, she pays you $4,713, and she goes away. If she's not a good doobie and says, come after me for it, you then have to sue her. And then when you sue her, the presumptive amount that she owes is not $4,713. The presumptive amount she owes is $900 less. That's what you said the legislature intended, that basically if you actually pay the amount that you are owed, you're a sucker, because if they sued you, you'd be suffering, you would enjoy the presumption that says you'd get the fair market value, and that would be basically $1,000 less.
In the case of Ms. Williams, if we did sue her, which of course we haven't and don't intend to do, we would, I believe, prove up that the fair market value is the amount that we got, which she has admitted is the high. It was procured through a system designed to get the highest possible price. So it doesn't make that person a sucker. What would be?
Because you would say that the fair market retail value is what you got, or because you say it's not fair market retail value?
Because we got the fair market value.
Okay, but
or
that's
put it
not
this
going to
way.
wash, because it's either retail or wholesale. It can't be just fair market value. That doesn't
But that's
help
the
us.
phrase that the legislature used.
I understand, but we have to interpret it. That's what we get paid.
I understand that as well, but the fact is that fair market value is a concept that is not a single number. In fact, even if it said fair market retail value, there could be a debate about what the correct number is.
Well, I
You look at
understand
these
that.
different, right? So that means that this court does not have to say that fair market value always means wholesale value or always means retail value. What the First Circuit has asked is, does it always mean retail value? And the answer to that has to be clearly no, because the legislature would have said that if that's what it intended, and it didn't say that.
So your point is that Honda, by doing this, is sometimes taking a loss, is that correct?
Honda is it takes a loss on virtually every repossession.
So that's tax, but is that a tax deductible loss based on the proceeds, the proceed amount, or the fair market value amount?
I don't know.
Or the retail fair market value amount?
I don't know. I know that they take a loss and that their interest is recovering every possible penny they can possibly recover through these resales, because it does not expect to collect that money from the debtor.
But I'm just talking about on the tax.
On the tax side, I'm afraid I don't know. I'm sorry.
Can I ask, so say I agree with you on point one, that the fair market value is the auction value, but I also agree with the way Chief Justice Gantz formulated the second part, which is that we're going to presume that if you sue, the game changes. We're going to presume that we use retail value as a starting point, and we know that the wholesale auction price is different from the retail price. So we're going to have a fight. But we have these notice provisions in question 2 and 3. So how would the notice, can you win on the notice as it was given out in that context if the notice has to alert them that there's a difference here? Because your notice just sells, we sold the car at this amount and you know, the difference, right? It doesn't point out this fight on presumptions that the consumer has the right to play out if you sue. So how does the notice part of this, questions 2 and 3, work if you don't win on the second part? You win on the first part, but you don't win on the second part.
So if we're talking about questions 1, 2, and 3,
Right.
I think if we win on question 1, we should.
If you
2 and
win
3
only in the sense that, I agree with Judge Easterbrook in that Seventh Circuit thing. The auction value is a fair market value.
Right.
But the legislature in 1970 was suspicious of this process and says you've got to look at the retail value if you bring a lawsuit. So how does the notice read to the consumer that they don't buy the Seventh Circuit's analysis and you get to fight over that? Because that, to me, is what's going on here, at least one person's opinion.
Well, if the legislature wanted to impose such a requirement in terms of what you put in the notices, it could have said so, and it did not.
But can you win under this theory given the notice you gave, which didn't alert them to this fair market value presumption thing?
Absolutely, because if you look at the UCC, and in particular sections 9-614 and 9-616, they're quite specific in saying what the creditor needs to put in its notices. And the safe harbor provision of 9
But doesn't the MVRISA or whatever it's called trump if it's different?
the UCC applies unless displaced by the Retail Installment Sales Act. You can see an example of the Retail Installment Sales Act displacing the UCC when it says you can't even send a notice to try to collect a deficiency if it's less than $2,000.
Isn't it displaced by E2?
Not at all, because E2 describes a presumption that arises in a particular context, namely a deficiency proceeding. That's the phrase it uses in E2. It doesn't make sense to apply that in the context of putting together a form. Is a Honda employee supposed to start with a presumption of a retail number and then persuade himself that it should be a different number?
How does the consumer know that you're not right, that they have some extra right out there to challenge this based on fair retail value? Because they do have that right, don't they? The presumption is this. You have to disprove that presumption. Don't they get to know that?
Well, certainly they can. I mean, just like anybody else, they can. It's in the statute books. But in terms of the notice that Honda is obligated to provide, again, if the legislature wanted to impose that requirement, it would have done so, and it could have done so, but it didn't do so.
So you're saying that if we find that indeed it was displaced, you lose because you didn't do it. You're resting on the fact that we conclude.
Even if we lose on the displacement of well, it depends on which part you're suggesting would be displaced.
Then basically, they displaced the fair market value as opposed to the actual amount of proceeds.
If fair market value, contrary to the actual phrase in the statute, really means fair market retail value, contrary to everything that we've been.
I mean, for this, you can just say fair market. But you'd have to at least say fair market value. That's what's displaced. We can debate whether it's wholesale or retail.
Then no, we would still win on the questions 2 and 3 because we did provide information about the fair market value, which is the value that we obtained.
So I am the average consumer. I probably am. I look at this and I say, golly, I guess I owe $4,713 because I'm in the amount of the gross proceeds is what it was, and I can't challenge that. But if I look at this and I see fair market value as instead of gross proceeds, I can say, wait, I know what the condition of that car was. I can go to the Blue Book. I can look to see that the fair market value is much greater. I'm not going to pay this deficiency. You didn't give me fair market value. Go ahead and sue me. And if you sue me, then I'm going to have the benefit of the presumption, which is a retail fair market value.
If you're a consumer looking at the Blue Book, you would see not just retail value, you'd also see wholesale value and trade-in value. And unless the phrase said fair market retail value, you wouldn't know which one we'd be talking about. More to the point.
So doesn't that go to the point that we, if we're going to be fair to consumers, need to say that whether fair market value is retail or wholesale? Otherwise, it's not really something that consumers can make benefit of?
Well, you're describing an issue that the legislature could, if it chose, address, but it hasn't chose to address that. I understand this court has to interpret the statute, but again, every indication in the statute that we've seen is that fair market value does not mean fair market retail value. And it goes back to the fact that the legislature could have easily just put that in there. We wouldn't be here today if they had done that. That was a conscious choice to leave that out, to only create a presumption only in the context of a proceeding for a deficiency. And in light of that, Honda acted entirely consistently with law by putting as the fair market value, or at least a fair market value, the amount it was able to obtain for Ms. Williams' car.
And tell me why a legislature which is upset about the extent to which car companies are selling for less than fair market value and during their repos deals, why would they affirmatively choose to have ambiguity on this issue?
There's no ambiguity here. There's no ambiguity
There is ambiguity.
whatsoever.
It's ambiguity as to whether it's retail or wholesale.
No, because even if it said retail or wholesale, there would still be ambiguity, because even...
Of course, there's some uncertainty as to what it is, but there wouldn't be ambiguity as to what you're trying to ascertain.
Exactly, and so they created this presumption in the specific context of a proceeding for a deficiency, which is not what we're talking about here. But other than that, they rely on the good faith of creditors to put in a fair market value of the vehicle. And that can be ascertained in a number of different ways as long as it's done in good faith, which it clearly was here.
Okay, so let's assume we have a deficiency trial. I assume it can be a jury trial. What do I tell the jury as to what the standard is for the jury to ascertain? Is it fair market value at the deficiency trial with regard to the retail value, or fair market value as to the wholesale value?
I think you would not say one or the other. You would
Okay, what if the jury asked me?
You would say to the jury that you would describe the presumption exactly as the statute creates it. You would describe the presumption, and you would tell the jury the standard thing. You would tell the jury about how they deal with presumptions, that a presumption is just a starting point. It can be rebutted with evidence. If Honda comes forward with evidence that, in your judgment, rebuts that presumption and establishes that the fair market value was what it actually obtained at the sale, then you should fine for Honda.
And then I get a jury question which says, are we to use the fair market retail value or the fair market wholesale value? What do I say?
It does, because the statute doesn't answer that question categorically. You could say it's a question for you to decide.
It's the question of law.
Just like if
it's a question of law for the jury to decide as to whether it's a wholesale or retail.
It's a fact because they have to just suppose it said.
Not a question of fact. There are two different values.
Hold on. I'm sorry. If it said, suppose the statute had said fair market retail value.
You're from Chicago, I understand.
I apologize, Your Honor.
Okay.
If the statute
City
said,
of strong shoulders at school, it's great. No worries.
If the statute said fair market retail value, and the jury came back and said, hey, should we use the retail value is set in the Blue Book or the Black Book or the NADA guide? Well, that's the same sort of thing. The statute doesn't answer that question.
I understand, but you tell them it's either fair market value of the retail or fair market value of the wholesale, and then you can consider the totality of the facts to do that, but you'd have to guide them as to what they're doing.
I see. If the legislature had said fair market retail or fair market wholesale, then certainly the court could provide that instruction. But again, because it did not say fair market retail value, or for that matter, fair market wholesale value, it would still just be a question of fact for the jury to decide after considering the evidence.
Okay.
Can I just ask one? Thank you. I have an easier question, but I'm not sure the answer is easy. So the Pinty analogy argument is not about E1 or E2 as far as fair market value or retail. It's that the notice that you are sending out doesn't include fair market value. So putting aside retail or fair market value, why isn't the notice insufficient?
Because if the Retail Installment Sales Act were going to displace the UCC in such a dramatic way by taking the safe harbor presale notice from 9-614, the very specific list of information that's required by 9-616, including the indication of what the proceeds of the disposition were, so on and so forth. If the Retail Installment Sales Act really meant to displace those provisions in quite so dramatic a fashion, it would have said so, and it didn't do so. So keep in mind too that I know that there's a statute of construction that talks about if the purpose of the statute, which this one is to help consumers. You look through at it through that lens. You also look at it through the lens of trying to ensure that statutes are harmonious, that they work together. And it's fine for the Retail Installment Sales Act to displace the UCC if it does so and provides fair notice to creditors that it's doing so they know how to behave. But it didn't do that in this case. So in that circumstance, following the letter of the law under the UCC was entirely appropriate and entirely lawful. One last comment, if I may. I talked this morning about notice to Honda. If this court, a majority of this court, decides that any of these questions against Honda, we would respectfully submit that any such application of that change, I would say, dramatic change in Massachusetts law ought to be prospective under the standards that this court has set.
Thank you.
All right, thank you.
Thank you so much. And again, I apologize, Chief Justice Gantz. I didn't mean to be out of line.
Not need to worry. Not need to worry. It was a helpful exchange.